Good evening. I'm Bhargav and you're watching the first video in the series Legal Talk for the Layman. In this series, I'll be bringing to you all the latest legal updates, whether it be a judgment passed by a court or a law passed by the government. All of that in layman's terms. So, in today's video, I'll be talking about the position of tenants in the COVID-19 pandemic. So, without further ado, let's begin. So a lease or a tenancy is generally governed by the terms and conditions which are mentioned in the lease agreement. If there is no lease agreement in writing, then the tenancy will be governed either by the Transfer of Property Act, or in case if it's a special tenancy, then it will be governed by a special law. But no matter what kind of tenancy it is, there are two basic aspects of each and every tenancy. Number one is that you have to pay a monthly fixed amount, what you call as a rent amount, and in case you fail to pay this rent amount, then the landlord is entitled to evict you from the premises by following due process of law. Now, when I say due process of law, it means that the landlord cannot forcibly physically evict you from the premises. The landlord has to follow the due procedure to terminate the tenancy and approach a court of law to get an order of eviction against you. Now, if the landlord does not follow this procedure and forcibly removes you from the premises, then you are entitled to ask for restoration of possession from a court of law. And the court will restore your possession without even checking whether you have breached the terms of the agreement or not. Now, all these rules and regulations work very smoothly in your regular course of life. But with the spread of COVID-19 pandemic, the situation has changed. Economic activities came to a standstill, there were lockdowns imposed across the country, and tenants could not earn any income so as to pay rent. So the landlords became anxious, and there were large scale evictions, illegal evictions across the country, which led to migration and spread of more COVID-19. So under these circumstances, the government had to do something which was unusual, and the government invoked what is known as the Disaster Management Act. Disaster Management Act is a special law which enables the government to take care of extraordinary situations like this pandemic. And the government can pass special orders to regulate the society in general, and violation of these orders can make the violator liable for imprisonment up to a period of 1 year, or with fine, or with both. So the Government of India invoked this Disaster Management Act 2005, and several orders were passed by the Ministry of Home Affairs. Now, two of these directions created a lot of confusion among the tenants. These directions were passed by an order dated 29th of March 2020, and these directions were: number one, wherever workers including migrants are living in tenanted accommodation, the landlords of those properties shall not demand payment of rent for a period of 1 month. Secondly, if any landlord is forcing laborer and students to vacate their premises, they will be liable for action under the Act. Now, this particular order created confusion because a lot of tenants were under the impression that their entire liability to pay rent had been waived off, but this was not the case. If you have a closer look at this order, basically you will realize that nowhere did the order exempt the payment of rent, neither did it waive off the liability of the tenant. It basically said that the landlord cannot demand the rent for a period of 1 month. This does not prevent the landlord from subsequently recovering the arrears of rent. Secondly, it said that the landlord cannot physically or forcibly evict these tenants outside of the premises, whether it be migrants or students. But this is even otherwise the position of law, because as we just discussed, a landlord cannot physically evict but has to approach a court of law to get an order of eviction. So the only consequence of this order was that if the landlord, in the face of this order, forcibly, illegally evicted any tenant out of the premises, then the landlord was liable for criminal prosecution under the Disaster Management Act and could be liable for imprisonment up to 1 year. So in the face of this, a petition was filed before the Supreme Court, where the petitioner sought that the MHA, that is the Ministry of Home Affairs orders, be implemented very effectively. But the Supreme Court was not inclined to interfere in this matter because the Disaster Management Act itself provides a mechanism for punishing violators. Now, after this, there was another petition filed before the Delhi High Court where it was argued that the COVID-19 pandemic should be treated as a force majeure, and therefore the parties to the lease agreement should be exempted from performing their obligations. Force majeure basically means superior force, and it's a general principle of law that when there is a superior force that interferes with the performance of a contract, then the obligations of the parties to perform the contract are suspended temporarily during the existence of the superior force. Now, this argument was rejected by the Delhi High Court because, in the context of tenancy, force majeure is defined under the Transfer of Property Act, which says that force majeure would suspend the obligations of the parties only if the tenanted premises is destroyed or rendered substantially unimpaired from being used. So only if the COVID-19 pandemic had to result in this kind of a situation where the tenanted premises could not be used by the tenant, only in such a scenario the tenant would be exempted from paying the rent amount. And finally, there was a second petition filed before the Delhi High Court where the petitioner had sought a blanket waiver of payment of rent during the COVID-19 lockdown. The petitioner had argued that tenants were not able to pay rent amounts and therefore they should be excused from paying rent amounts in general. Now, this petition was of course dismissed, and the Delhi High Court observed that it ought to be kept in mind that courts cannot do charity at the cost of others. Charity beyond law is injustice to others. While saying this, the Delhi High Court explained that a lot of landlords are in such a situation that they are entirely dependent on the rent amounts for their livelihood. Some of them are widows, some of them are retired persons who have no other source of income except for the rent amount. And also, there are scenarios where the tenanted premises are commercial premises such as malls, retail stores, shops, in which case it would not make sense in waiving of the rent amount. So, under these circumstances, the Delhi High Court disagreed with the contention that rent amount should be waived off in general. So, to put it all in a nutshell, basically the tenants were never exempted from paying rent, the rents were never waived off, and the landlords can still file a suit for eviction against tenants. But if the landlords forcibly evict tenants from the premises without following the due process of law, then the tenant is firstly entitled to be restored with the possession, and secondly, the landlord would be liable to be prosecuted under the Disaster Management Act. So that was all about the position of tenants in the COVID-19 pandemic. If you have any queries, post them in the comment section below and I'll try to make a Q&A video covering as many as I can. In the meanwhile, subscribe to the channel to stay in the loop. Thank you for watching. I'll see you in the next one. Bye bye.